Okay.
Thank you.
So we are now going to go to Commissioner Macharia Jero for you to ask your questions, Commissioner.
Okay, thank you, Chair. My Lord, thank you. Now, I'll take not more than 30 minutes with you. And I'll start with the sample writings, my Lord, that you provided.
Yes, sir.
Now, you are referred by my colleague, Commissioner Majanja, about this case of Professor Misia Manuguti Kadeni.
Yes.
I'll come to that later. But there was a similar case that you had decided, which you provided a sample writing. The one relating to Samson Olekisirkoi.
They are cousins.
Masai Mara University.
Yes.
Now, and what I noted in the same case, of course, you also made reference to your personal case, where you also referred to your colleague judge as my friend and brother. I'll come to that later.
Please do.
But when it came to the kind of awards that you made, I couldn't follow, and I'm asking this because I need to understand your jurisprudential leadership if you become the Honorable Chief Justice. Because one of the things that you did is that this was I think he must have been the Deputy Registrar Administration in the university.
Yes.
Now, who had been terminated.
Yes, sir.
Now, you started by saying, of course, you reinstated him, you ordered that he be reinstated. But one of the things that I found I couldn't understand, but you could explain to me, is that the date when you issued the judgment, you said that I hereby order that the petitioner reports back to work tomorrow, the 1st February 2018 at 8:00 hours. You know, basically
Yes.
saying tomorrow by 8,
I appreciate.
you're back in the office.
Yes.
Now, which I was wondering that whereas of course you'd be able to grant that kind of an order, whether as a judge you don't see any practical difficulties in that, in not granting at least some reasonable time even as you are granting these rights, balancing it with some reasonableness. Because you'd imagine if somebody has been away for over 2 years, you know, the employer would even require probably to put in a desk, arrange some administrative measures to make it practical for this order to be effected. What could inform your decision to be so drastic as not to even grant that reasonable time?
I don't know whether you want a very direct question. Because I can give you a background.
Yeah, but not too long. That in the interest of time. But you have your day. That's all right.
Yes, I have accused myself of being the judge in that court who is all too free on reinstatement. Having said that, and with my issue in my reasoning in mind, that employment in Kenya is like a matter of life or death. Whenever you can get back to work, please get back to work. Two, the immediate date. In this case, we have established a case of unlawful termination of employment. That is ugly enough. You've been out of work for so long. Another very ugly situation. You've gotten judgment in your favor. The practicability of, giving you time to return to work, to me, would not make a lot of sense. Because the employer is there, he has offended you, he has transgressed your rights, he has made you suffer for no good reason. What is this so critical situation, which would be worse than what you have suffered, that would require that we give you 2 months to resume work, etc., etc.? I have never thought that it is impractical. I've always thought that it is immediate, and that is what I have done in all my cases of reinstatement. I have never considered that I am being offensive to the employer. If the employer finds that he is not ready or etc., I have returned your employee. Deal with the situation. That is a domestic matter. The judge has done his work. And to me, that makes a lot of sense. If I am faulted by other quarters, I am agreeable.
Then in the same decision, you went ahead and said the respondent be and is hereby ordered to meet and pay the respondent's salaries and allowances owing but unpaid during his suspension, which is all right. So basically, you are compensating, the petitioner for the time that you found that the termination was unlawful. So you are reinstating them, kind of like putting them back to the same position they were before termination.
Yes,
but which is fine. But my problem again now, which I couldn't understand, of course, I'm not the judge here, just need to understand your reasoning. You go ahead again and say you're also awarding 6 months' salary as compensation for unlawful termination of employment. So you are not only giving the salary during that time, plus all the allowances, you are reinstating them to that position, but you're also adding another burden of another compensation on top of the compensation you've already awarded. So, I mean, I'm not really getting, what is the reasoning behind that and the fairness in it, the justice in the matter. Could you kindly just expound on the jurisprudence behind that?
The issue of the 12 months compensation, which must not necessarily be 12 months. 12 months is the limit. You could do a month, you could do half a month, you could do 3, 4, 5, 6, etc., etc. And Section 49, 1C of the Employment Act is not in entirety the total compensation available to a case of unlawful termination of employment. The judge has the discretion to look for other remedies which are available and which have been prayed for to offer. And this will depend on the circumstances of the case. The judge exercises his discretion depending on the circumstances of the case. By the time you do the matter and finalize, you've gotten the gist of the matter, you've gotten the involvement of the parties, etc., etc. That is what dictates what you offer the aggrieved party. And in the circumstances of that case, we are compensating unlawful termination differently from any other issues of compensation that may have arisen in the circumstances.
Yeah, that's all right.
That is allowed.
Yeah, Judge, but it's only that again the discretion must be exercised, should not be exercised whimsically. And again, you see, you already compensate the person. But I don't want to make it an argument, I just need to understand your jurisprudence. But now, you've reinstated the person, which is fine. You say they be paid all their salaries and allowances, which again is fine, I don't have an issue with that. But now again you are saying a permanent injunction be and is hereby issued restraining the respondents from commencing any process towards replacement of or replacing the petitioner in the position of Deputy Registrar Administration. Now, if they are already back in the position and you've compensated them, but you are saying that there should, basically what you essentially are saying is that there should not be any process towards replacement. So if this person misbehaves again, it means then that the hands of the employer are tied. They can never start any process. So again, what is the reasoning around that?
Thank you, good counsel and commissioner. I relied on the historicis of that matter, the background and the data available, the evidence in the matter. What did I hear? What did I know? etc., etc. The environment was so hostile that we had to safeguard the position of the employee when he goes back to work for various reasons which are very, very clear, that that was a very, very hostile affair. And two, the issues which they were fighting were not issues which were industrial. all evidence will tell you that it is personal. So when it is personal and you can see it so clearly, you may not be able to declare it or say it, etc. What you do is issue as much safeguards as are possible to the employee. The employee and the employer are not equal. This is an interplay of labor and capital. Capital is always superior. So you safeguard you safeguard labor depending on the circumstances. You safeguard the capital, or you remedy their situation depending on the circumstances. In that, under those circumstances, and knowing the matter the way I did, I was convinced that that gentleman required, the claimant required security in his employment.
Yeah, but you see, Honorable Judge, when you are telling an employer that you should never touch this person for as long as they're an employee again.
Oh, thank you.
Basically,
thank you.
You're tying. But let's move to the next.
I could answer that very briefly.
Yeah, please go ahead, Judge.
You choose.
Yeah, please go ahead, Honorable Judge.
That was not permanent in that sense. In fact, when he resumed employment on day 3, he missed. They would restart the process. That was supposed to deal with that situation, the situation we were adjudicating, not anymore.
Yeah, but you see, the way your order was framed had the opposite effect. That's the problem I have, and that's why because I'm asking you jurisprudential questions, because you'll be the leader of jurisprudence in the institution. So that's why I'm asking that question. But now, let's test your decisions, because I had to again now do a bit of research, because this matter of Professor Misia Manguti Kadenyi, the one you asked by my honorable colleague. Now, I went ahead and actually noted that it's a matter that was a subject now of the Court of Appeal. It didn't end just with your court. And now what I noted is that, for instance, the award that you had given in this Professor Kadenyi case, apparently what you had done is that you had awarded compensation, you had picked a salary, which you awarded against the employer, which was not supported by any evidence at all. The evidence was based on the evidence that had been given to you was showing a monthly salary of 333,640, but you picked instead 658,112. In fact, the court said, we have carefully gone through the judgment of the trial court, and there's no indication at all where the monthly salary of Kenya shillings 658,112 is taken from. There is therefore merit in the submission by the appellants, and this figure is unsupported by the evidence. And we therefore set aside the learned judge finding the monthly salary of 658,112 and substitute therefore with a monthly salary of Kenya shillings 333,640. So you can see a problem whereby you are probably making a decision based on other considerations, probably emotions, and I can see you keep, in all these decisions, you keep quoting your personal case against TSC, which again in this case, you are being accused even by the appellant, saying that you seem to be relying more on your personal experience with the National Teacher Service Commission, and there seems to be anger and, which is because of probably you are feeling that you are mistreated, you are now transferring it when you are now deciding decisions. So, I mean, wouldn't you consider this to be a serious indictment even by the Court of Appeal regarding how you are making decisions of a mandatory nature against employers and supported by evidence? I don't know what would be your consideration to that, Honorable Judge.
On the first issue, the issue of the amount which was multiplied as a compensatory figure, the 629. Section 49(1)(c) of the Employment Act covers that. Section 49(1)(c) talks about gross salary, not net salary. The employment law does not know net salary, because when we are compensating you for unlawful termination of employment, we go by the law, and the law provides that we use the gross salary. So what a judge on finding of a situation of unlawful termination of employment would look for on the pleadings is all the itemization of dues. I was paid 4,000 shillings as a basic salary. I was paid 1,000 shillings as a house allowance. I was paid 500 shillings for a transport allowance. That is what you add up, and that is what I did to get to a figure of 629, including the car allowance, which was, if I remember right, 129,000 shillings. So you add all that, you must accumulate all that to get what we call the gross salary. And that is what now, in your discretion, 1 month, 2 months, 12 months, 10, blah, blah, etc., etc., you use as a multiplier effect to get the figure. The Court of Appeal, we may not be able to correlate. It buys us insofar as that matter is concerned.
Yeah.
But going back to, to ourselves, we would always want to ask ourselves, which is the earlier? Is it the Court of Appeal and its findings in the professor's matter, or Kisirkoi's matter, or the Employment Act? A big question.
Yeah,
I have answered your questions. If I haven't, I could
well,
continue.
the principles of stare decisis bind you. This is the Court of Appeal. Now, again, then, my lord, again, you see, in Samson or like Kisirko, you made that order that the employee reports the following day. And what I noted is that in again Professor Misia Kadeni's case, you did the same thing, ordered that, report tomorrow. So in the Court of Appeal, this is what they had to say about that issue. We wish to state that in instances where the court is satisfied that an order of reinstatement is deserved, it is not prudent to direct that a claimant reports back to office within a day from the date of a court decision. Such a drastic order is likely to present considerable implementation challenges to an employer. In our view, a reasonable period, depending on the circumstances of each case, ought to be given for the reinstatement to be effected. So you can see when the Court of Appeal is saying that is too drastic, there has to be reasonableness. And you see, the reason why I'm asking this is because you'll be our Chief Justice if you become one. Now, the issue of reasonableness now starts arising in your decision-making process. I don't know whether that makes you change your mind regarding those kind of drastic orders that you keep making, that, I'm issuing an order, I want it implemented immediately without considering the challenges that would arise from the implementation. Not just in the decisions, but even in your day-to-day decisions that you could make here as our Chief Justice.
Well, thank you, good Commissioner. We are open to learning. That is one, first and foremost. But like I said earlier, that is what I have practiced throughout my career, 10 to 9 years in that court. Nobody has raised an issue on that in the past. The matter you are referring to was not an ordinary matter. There were other, side issues relating to the matter. As the Chief Justice, we would not like to do anything which hurts anybody, even as judges of the employment court. I would never have imagined that when I tell somebody to go back to work the following day, there would be an issue, because employment is contracted. The employer could go back the following day and is given a week's leave. In any event, he's been away for so long. The employer could go back the following day, and then another different arrangement is made. All those factors come into my mind when I said that. The agency I created, not because I want to make it impossible for anybody, not because I want to punish anybody. I want to, it's an indication of urgency. It's an indication of seriousness insofar as labor relations is concerned at the workplace. I am telling everybody that good enough, you are secure when you harmonize your relationship with your employees. When you don't do that, and you deal A, B, C, and D, what we shall do is we shall tell them to return. And not because we want to be offensive, but because it is their right. But primarily, I think the whole matter is open to the employer and the employee to deal with that aspect. And if we don't have impossible situations, because we are human, when it becomes an impossible situation, there's no employee who takes charge of an industry. So if he's told by the employer now, you can come back in 2 weeks, 3 weeks, etc., that would be okay. That would be good practice. You will not insist that it just sticks there and it stays there, and there's the fruits of immediate restatement.
Okay, Honorable Judge, just 2 more points on that decision.
Please.
That we move to something else.
Yeah.
Again, you see the same decision of a prof. Now, the evidence was very clear that the position of Deputy Vice Chancellor, Academic Research and Student Affairs had already been abolished. But that notwithstanding, you still went ahead and said that I'm reinstating you to this position. Now, again, I'm not able to understand why you would insist on reinstating somebody to a position that no longer exists. And in fact, to that effect, the Court of Appeal again said, considering that the position to which the respondent had been appointed had been abolished, we think that it was not an appropriate case to order reinstatement. Balancing the interests of the parties tilted in favor of not ordering the reinstatement, we therefore allow this ground of appeal. So why would they take for the Court of Appeal to be the one now to see that it doesn't make any practical sense at all to order a reinstatement of somebody to a position that does not exist? So again, I'm not understanding the reasoning, around that.
If you get to the background of the matter, you appreciate that that was not a matter industrial relations. The issue was not industrial relations. The issue was personality. You versus somebody else. The Vice Chancellor versus her deputy, etc., and it was not even more personal. It was strictly a personal matter.
Yeah, but
so when it comes to me, and I take that evidence, you say that the place, the position has been abolished. That is your evidence. The other one says that no, the position is not abolished, and if it is, it was not done in good faith. So where does that leave us? When we get a situation like that one, we have a over-insistment in that kind of circumstances, we have the most obvious choice. That one of getting back to a position similar to, getting reinstated to a position similar to what you have. But looking at the historicis of that matter, I thought that we should not encourage personalization of industrial relations, of employment issues or employment contracts. Let her return to that office in the same position. The balance belongs to them. The Court of Appeal, I
agree with you, but you have to always remember that you have to remain a judge based on the evidence, the facts, the law. And you see, this is a case where there was an opportunity for either reinstating to that position or the position of the professor to continue teaching. You reinstated both. The first one was okay, even the Court of Appeal agreed that the one of the professor, that's fine. But this other position, because teaching is always teaching, so you can't say you've abolished teaching, so that's fine. But you reinstate someone to a position that does not exist. I mean, don't you think then that you're putting, the employer in a situation that they can't actually be able to comply, making orders that are in vain,
I am saying that there was evidence wholly on the situation on the ground. There was evidence to the extent that this matter was not so much employment or industrial relations. It was a matter which was, personal. The Vice Chancellor and the Deputy Vice Chancellor.
Okay.
etc.
Yeah.
And that is why I dealt with it that way.
All right, we leave it at that.
The Court of Appeal has come its own style.
Yeah.
It has taught us one or two things.
Yeah.
I had other options, which I chose not to take for various reasons. I get it.
Yeah.
I am
Then
guided.
this issue of keeping on quoting your case was also submitted on, extensively. It was found to be, whereas it's a matter of your choice, but not tidy, as was also observed in a passing. But now let's leave the cases now. Let's discuss now you as an individual, so that if you come here with us, be with us, we can see whether you can be able to do the job. Now, you asked about the question of collegiality in the Supreme Court, where it would be now the president of the Supreme Court. I would want to understand, like, for instance, if the disagreement among the judges there, and you be now their president, and I'm talking about disagreement, not about personal disagreements. I'm talking about disagreements on decisions. Now, I would want to understand, again, not in so many words, how you'd want to, which way you'd want to go in terms of managing it. And I'm asking this because, not because of our Supreme Court, because I took interest in some matter in the Supreme Court of US, small versus Memphis, light gas and water, that is the case, where the Supreme Court declined to take over to take an appeal which sought to review a famous case of 1977, which would have reversed a precedent that had been established in the US. But two of the judges disagreed, with the refusal by the other judges, specifically Neil Gorsuch and Samuel Alito. And they actually went public, wrote, a decision totally disagreeing with their colleagues and all that, and went public. And of course, the other judges were quite unhappy with that kind of with that line of action. How would you deal with a situation like that, and what would be your preference in managing a situation like that?
This is an experience I may not have. It's an experience I am going into immediately when I become a Chief Justice of the Republic of Kenya. So how do you manage that? At our induction course many years ago at the JTI, we were taught elaborately the subject of collegiality by one of the commissioners here, the Honorable Attorney General of the Republic of Kenya. And this simply means creating brotherhood. Judges are limited in decision making. I mean, there's independence in the decision making. But my understanding of collective decisions, like the ones of the, big bench decisions, is that these are negotiated. There is a conference, there is a conferencing, and after conferencing, they get to level 1, maybe level 2, agree, and if there are any dissents, the dissents also take their place. So, in the circumstances of that kind of situation, however hard the matter is, the judges of the Supreme Court have a duty to deliver justice or to make determinations in all matters, regardless of their intensity or difficulty. We cannot just come out and resign and tell Kenya, no, this one is beyond ourselves. So you see to them.
Okay, so you'd agree with me that experience in managing, even a bench. You said you've never been in a situation whereby you've sat even with colleagues in one bench. I think that's what you said, that also is it's necessary to have that kind of experience, which probably you know.
When we get to the Court of Appeals, to the Supreme Court, I'll be one among its equals.
All right.
There are many judges there who have vast experience in these matters, vast experience at the Court of Appeal, vast experience at the High Court. So there's nothing we lack. It's just a question of teamwork. You can, get off the chair over the Supreme Court in a session where we are doing the conference, and hand over to somebody else who takes charge and guides everybody and leads, and teaches. In fact, a colloquium is an issue of teaching, it's teaching idea. Sorry, not a colloquium, but a conference. It's a teaching and exchanging and sharing differential, merging differential, etc., so that you are able to create a consensus. And that is where we are. The issue of being Chief Justice and Chairman is just peripheral. I mean, this is a team of equals. And we must always recognize that there are two types of seniority, insofar as the legal profession is concerned. The seniority based on the date of admission to the role of advocates, seniority based on the date of appointment as a judge, the date of entering that role. So those must be taken into account. But overall, knowledge, expertise, experience, goodness, cleverness, and what have you are not an issue of possession. They are an issue of knowledge. Knowledge is basically knowledge. You know or you don't.
My Lord, I was referring to the experience.
Honorable Judge, maybe you can be addressing the commissioner asking the question. With respect. It's good to address the commissioner asking the question first.
I was referring to the experience. You see, the High Court judges, sometimes you find that a bench has been impaneled, so they manage that. Same thing also in the Court of Appeal, of course, they deal with benches, and Supreme Court also, they sit, and many of them. That's what I was referring to. But again, I'm wondering, you said that when you were asked one of the questions, I think it's when you were asked about leadership, and you said that you've not sat in any big office, and you actually talked about having risen up to, I think, senior state counsel. And then you referred to being a senior, I think, legal officer or something at the TSC. Then you became a judge in industrial court. Now, so I'm wondering, if we give you again this position of the Chief Justice, which is quite senior, where you are responsible for for a lot of resources, a lot of issues, it's an arm of government with many responsibilities. Now, I don't know what you do to convince me that the learning curve wouldn't be a challenge, because we can't take chances. It's a position. You see, there's a position that there's also very high expectations from Kenyans, the members of the public. Now, I'm just wondering, as the Judicial Service Commission, how would I, for instance, as a commissioner, account to Kenyans that I've given to my Lord, yet, the burden of proof on his part that he is equal to capacity, not based on what he's telling me that he'll do, but based on his past, that he can be able to prove that he's equal to the task. How would I be able to account to Kenyans? I'm asking this with tremendous respect, not to demean what you've done before, but I'm just saying responsibilities versus what you've done and the office. How do you convince me so that I can be able to give you marks with that in mind?
In the first parliament, 1963, when we got independence, most of our cabinet ministers were less than 30. They were politicians. We had not been, we had not ruled ourselves whatsoever, but we walked through. Mzee Jomo Kenyatta was a president. He has not been a president whatsoever. He was just an activist, a politician, a freedom fighter, but we walked through. What we are saying is that to gauge what I'm capable of doing as a Chief Justice, look at what I did in Sharia House in 1.5 years between 1985, 1st of August, and January 1987. Gauge that, look at it, etc. How did I relate? How did performance, etc. Whom did I lead? Whom didn't I lead? Because then when you get people from, people, your clients coming in and walking happy, and you do a job and you get results, there must be a sizable amount of leadership. We have not been in these places or in big office because nobody gave us an opportunity. You cannot hang us for that. Look at my personality, if you are able to, I don't know, that will be difficult for you as a commissioners. My personality, where have I been? Go to my village if you can at Chuka. Look at what I do. Do I own a cow or two, and how do I feed them? Etc. etc. Leadership is not an issue of office. And if that is not answering enough, learning does not take centuries. It is just a question of if we landed into that office today, would be able to sit there. Two, you are working with a team. I must not be ICT. I must not be HR. But we have people there who are HR. If I find them inadequate, I'll be able to bring expertise. So you, a leader, just sits there and implements a policy and shows the way. I went to the KIA for a course a long time ago in my TSC days, and we were taught about the difference between a leader and a manager. This is the difference. A leader thinks, states, and leaves. A manager is left by to implement. So if you have the idea, the implementation is not an issue for the leader. You have the idea and you say it. What you do as Chief Justice would not outrightly abandon management. You have to combine the two and be on the lookout. But we are saying that you cannot do everything. I am not a teacher, but all the schools around here would get taught if I was in charge of them, because I would get teachers and good teachers to do that. So you incorporate and you apply whatever resources, human resources you have to be able to get what you want. You lead.
Now,
and others follow.
My Lord, now you said, again I'm picking this from what you said, and
please.
I only have 3 more questions. That after you came back from the political seat that you attempted to get, you started legal practice, which lasted for 11 months. I'm just quoting you verbatim.
Please.
11 months, and then you decided to go back to employment at a Teacher Service Commission.
Yes.
Now, I'm just trying to understand what made the law firm not last beyond 11 months. Nothing wrong with that, but I just want my understanding so that I can see how to place you in terms of...
A very simple answer. I left the Sharia house to go for NITHI. NITHI was disastrous. I realized that I did not have any future. I was not a politician. I would not cope with it. So I came back to Nairobi to pursue my career, my profession. In the absence of anything else, I opened an office. I have always known that I am not a practitioner. Private legal practice, hands off. That is not my line. There are so many other things I can do in law, with law, but not a successful legal practice. I'm not your personality. I am myself. I have my limitations. I have my gifts. Private legal practice is not one of them. That is why you realize that after my horrid departure from the TSC, I go to Ongata Rongai and sit there and start a practice as a pioneer counsel in that place. 3 years down the line, 2 years down the line, I began teaching. Because for me, teaching is more of myself than a legal practice. In fact, if I had continued, I would have abandoned the legal practice altogether, because that is not myself. That is not my gift. Those are not the areas where I score and go to precisely where I score. 2, all this time I had realized that I am a public servant. That is why I sit here today. That is who I am, and that is the best. If you wanted to get the best result in me, public service.
Yeah, but you see, again, now my worry is that we could give you now the position of Chief Justice, and you are unable to, being a judge is one thing, but being a Chief Justice with all these many responsibilities is a different thing altogether. It's a different ballgame. So, again, I would be worried that perhaps, you may not be able to manage that position. I keep reminding you that for us, whoever we appoint, we must be able to look in the eye in a Kenyan and say, this is why, you know. So wouldn't that be one of the reasons probably that could create some doubts in our mind that perhaps we could give you that 11 months later you're not able to manage? And that time, and you see the removal process is a different thing altogether.
No, I don't see it that way.
Mm-hmm.
One, I don't see the link between, a Chief Justice and a private legal practice. Good, you relate with the practitioners out there, but you're not practicing yourself. You know how it is done. The only dilemma is that you cannot do it on your own. It is not your line. You may not be interested. You may not even know. You cannot be hanged for that. This is a public office, a Chief Justice of the Republic of Kenya, which, any able leader would be able to do, particularly if you are fast, like I am. You'll be able to sit there and get everything connected. You have everybody that you require. And if you don't have, you could always bring them in so that you use them to get what you want. You are the leader. Legal practice, private legal practice, and this office, this grandiose office of Chief Justice of the Republic of Kenya, to me, not.
Okay. Second last question.
Please do.
Now, you see, if you become the Chief Justice, you'll be also the chair of this commission, JSC.
Yes.
You'd actually come here and now be a primus inter pares. You know, you'll be the first among equals. Now, I'm just wondering again, because managing us, you can see we are all from different, we are representing different constituencies. But you have to put us together, and we are one cohesive commission, chairing us, and all that. And of course, it's not an easy task. Eh?
It will never be easy.
Now, tell me, what is it that you think you have that, gives you that ability? Because you see, this commission, of course, it has immense responsibilities vis-a-vis the institution of the judiciary. Because again, I'm looking at your CV, I'm looking at what you've done, and I'm still not seeing what is it that can be able to put you in that primary position of being able to make the commission function in a way that it's able to undertake its duties. And as you're answering that, this is the same commission, without getting into many details, you've already had so many issues with it, which you're aware of, and then that are still outstanding. So I'm still wondering, how would that work? Because, see, again, you can see the Court of Appeal is talking about tidiness, even as you are making decisions, as you are making certain considerations. I'm just wondering, how tidy would that be? That our chair now, will the chair come and start dealing with his issues first with us in the commission, or shall we get down with the business of making sure the commission is able to deliver on its obligations both to the judiciary and the Republic of Kenya?
The issue of ability is not an issue whatsoever. The Judicial Service Commission has its obligations, which are dictated by law and practice. Who is in charge or not in charge would not make a difference. In this sense, if we are committed to what we must do to fulfill our mandate as the Judicial Service Commission of the Republic of Kenya, and our roles are explicit, what it would require is that we move on to create work plans for implementation and acquisition of the end result. I would lead in that. But I believe that I'm leading 11 others who are committed, as knowledgeable, who have the goodwill. So that where I sleep, you raise me up. Where you sleep, I raise you up. So it is not this work. If the entirety of the Judicial Service Commission that we have today left, in a week we would have another Judicial Service Commission, and there would be continuity. the issue is not, where you have been. The issue is, are you able? I believe I am very, very able. I have a proven record. Go to Chuka, you look around, you see what I have done. Even, my coffee shop, I will tell you, this person is able. etc. I have answered. How satisfactory the answer is.
So my last another question, my lord. You know,
sorry, there is a, sorry. If you allow me, good commissioner, there is the second limb of the question. My issues with the commission. Do you allow me to answer that?
Yes, go ahead.
Go ahead. Thank you. My issues with the commission are not personal. My issues with the commission are as such issues with the commission. The commission would have the ability to deal with all those issues independently and freely, even if I was a chair. I'll just get out. That is what we do in the church or in any other meeting. If you are conflicted, or it is a matter which conflicts you, you take off and the others make a decision. Good enough, yes. Nine complaints. I do not generate complaints. Complaints are managed by the commission, and we shall not take that away from them. So even as a Chief Justice, as late as the other day, we knew and we had, it was public knowledge that the Chief Justice had complaints which the JESC would even ask him to answer for consideration. None of us is immune, and I thank God because Kenyans are at liberty to raise these issues, and we shall not take that right away, because that is what our independence is all about. We are accountable to them. They can raise 1,000 issues against me. I'll answer. If I fall, I am indicted, good enough. I pay the price. So my issues do not have nothing to do with
I'm all right with that, my lord. My final question.
Please do.
You see, the hard reality, regardless of what we may think, whoever is the Chief Justice must be somebody who must attract the respect of the peers, and of course, even as they enter and they take that position, Kenyans can say yes. The person must come up with that. It must be somebody who people can say yes, that's a person who is befitting of the office. I'm not saying you don't, but do you think you have that? That's all. That's my last question.
Thank you, and thank you again. We are looking for yes. It has been said very loudly, and I know that, and I'm not cheating myself. I can mark myself 90%. Kenyans have loudly said that is a man, the man of the moment, in the airways. I'm not talking about commission of Kenya. No, I'm not talking about radio. I'm not talking about TV. But if you feel the air around Kenya today, it is very, very, very clear. We have. I said that this is a man. Did you see the 2 reviews I had on the newspapers? The one on the Standard immediately after Easter, and the one on Sunday last. That is what I presume is the voice of Kenya.
Okay, thank you very much, my lord. I wish you well.
Thank you, and welcome.
Thank you very much, Your Honor. I will now request the Commissioner AG to ask you questions.
Thank you, Honorable Chair. My Lord Justice Marete, I would not wish to belabor you with too many questions, because many of which I would have asked have already been put to you and you've answered them. But just to follow up on what Honorable Commissioner Macharia has just been discussing. You seek this office against a backdrop of 38 or 35 odd years of experience. And you have attempted to persuade us that you are indeed the man for the moment. And you have sought to demonstrate that you would be able to learn and learn very quickly. And you said, my Lord, that you would engage the public as well as the judiciary staff, make them happy, motivate them, etc. Would you be pleased to tell us, Your Lordship, which existing organs within the judiciary currently which you would engage to enable you learn quickly and to achieve the mandate of the office? There are various organs existing within the judiciary as we sit here. Which are they, and how would you engage them?
One, we have offices and officers. The office of CRJ is very instrumental in the running of this institution. She's the CEO of the institution.
That's one.
The office of the very able Deputy Chief Justice. She's been in that position for long enough to be able to even be Chief Justice herself. It will require a hand-by-hand contact for a year, for a month, 2, 3, 6, 1 year, etc. That collegiality and the cordiality between those three offices is like the issue is resolved. Because through the Honorable, the CRJ of the Republic of the Judiciary of the Republic of Kenya, I'll be able to access all the other human resource which is available through reports, through any other means. The CRJ, the time she has been there, knows the judiciary and its operations throughout, inside out. And being here and available and knowing her personality so well should be a vital asset in helping us walk through this journey. The Deputy Chief Justice is here. The Commission is here in entirety, a big force, Judicial Service Commission. You didn't go to the other associations, the independent associations for like the KMJA, the Kenya Women Judges Association. These are institutions and organs which would be able to tell you and give you what you may require in terms of learning and be able to support you as and when you need it. They are your colleagues. You are not their senior. I would be able to work within a class 2 kid today and transact business. Why wouldn't I be able to work with everybody? Inequality, that is my terms of trade. Everybody who deals with me we deal at the same level, at parity. So all this crowd here of senior officers, the JESC, KMJA, the association representing judiciary staff, all those organs. If I wanted to borrow from them, it would be instant. And I believe they would be willing to lend a hand. And there we are. The judiciary, this is not personal. The Chief Justice is just there as a figurehead. The whole thing belongs to all of us in equal shares. And Kenya, equally.
What about in relation to the courts, my Lord?
The courts and the administration, we have heads. The president of the Court of Appeal. We have the various, principal judges, the principal judge of the High Court, the principal judge of the Employment and the Labor Relations Court, the presiding judge, or in quotes, the principal judge of the ELC, big consults. Beyond that, you can even go to the individual judges. I'm accessible to virtually, as Chief Justice, virtually everybody. And this place is rich. Do I repeat that? Look at who is sitting besides you. A giant, insofar as performance is concerned. An intellectual by excellence. And here we are. There's nothing we lack whatsoever.
Thank you very much, my Lord. Now, you discussed the jurisdiction of the Supreme Court in relation to election petitions. Would you be pleased to tell us, my Lord, whether you consider that jurisdiction should be expanded or restricted generally in the Supreme Court, but not in relation to election petitions?
The Supreme Court should be very, very guided and very guided in the way is the jurisprudence in the way the jurisprudence on the election petitions and generally every other matter is concerned. We read from Kenyans or even other scholars outside this country that as at the time of the elections in 2013,
my Lord, please, you explained the aspect in relation to election petitions. I should ask you now to deal with the jurisdiction of that court outside the framework of election petitions. Should the jurisdiction of the court be expanded or restricted, and if so, why?
I would not think that it should be expanded because, one, let's look at this at the basics of your question. The Supreme Court has expressed itself on that, and the ratio decided is to the extent that in all these other courts, the High Court, the Court of Appeal, etc., we have competencies which will be able to deal with any matters constitutional. I should even deal with that down to the magistrates' courts. These are professionals who have the capacity and the competency to deal with matters constitutional. That being the case, and looking at the circumstances and the basis of the Supreme Court, I would think the safest thing would be to narrow it, not to expand it, even in these other matters, so that you are restrictive and you are able to guard what you take in and do it very, very well, so that you become a guide, one, you become an authority in the region, and you are able to meet the expectations of those who created the Supreme Court. Because the Supreme Court has got its own histories, and that there was that which it was intended to cover. I would implore a very, very conservative and restrictive approach to jurisdiction in the Supreme Court, so that we are able to, one, cope, two, allow everybody else down there, the Court of Appeal. We are talking about rival jurisdiction as we speak now in the out there. I mean, we are talking about a rival jurisdiction, things which are extremely dangerous. Let's allow everybody to do their bit. Let the Supreme Court do what it was intended to do by the drafters of the Constitution through, the people of Kenya.
What was it intended to do, my Lord?
Primarily, the Supreme Court was intended to deal with the issue of a presidential election. In fact, if you are lay and heard of the Supreme Court in 2011, 2010, etc., post-Constitution. What everybody told us was that that was the most critical matter. But you know that cannot be done forever. The Supreme Court becomes a lead court, and it was intended to be that. Lead in terms of jurisprudence, so that you are not doing 1,000 matters. Do 5, 10, 100, and do them so well that anybody looking at them will be saying, I was guided on A, B, C, D. The thinking is brilliant. These people had their time in so doing. They were not rushed like we are rushed by backlog. So that you are able to come out clean and guide Kenya on its governance patterns. The framers of the Constitution put it right. Issues of constitutional interpretation, issues of constitutional interpretation and interaction, good enough. But now, when the Supreme Court itself now sits, what does it interpret this to be? And when it does that now conform with the expectations of the drafters of the people of Kenya?
And my Lord, how would you then, if that is your belief, what leadership would you offer in that jurisprudential development?
One, the issues which are in contention, the issues which have been raised by the Kenyan public and any other interested party, international, scholars and academia, etc., I would subject that to a public debate. They would be thrashed out, and they would have a policy which is not guiding on the decisions of the Supreme Court. We cannot tie the Supreme Court. As we do it at a public level, the Supreme Court would also be sitting to think. We would create a situation of reflection, a situation of introspection, a situation of consultation and rethinking, so that if we are convinced that there is a problem, we are stifling the other courts, we would deal with that freely and openly. But it would require the Supreme Court on its own to sit and reflect, introspect, and generally see what is available and what is offerable insofar as what we have today is concerned. Very convincing, very able, and a very good jurisdiction, if you ask me. But issues have arisen. If you read any of those matters and opinions and decisions, they are fantastic. They sound good and etc. 1,000%. But now when you come to the ground, other intellectuals are raising issues, and we cannot ignore them. They are part of our stakeholders. They are Kenyans. Quietly, we have issues even which are internal. Like the critique on my decision, the Court of Appeal judgment made very firm interventions on my judgment. This may not be that formal, but we have other areas which may be feeling uncomfortable with what the Supreme Court is dealing with and the extent it is. So we bring everybody on board, we thrash out the issues, we make recommendations and solutions, we hand it over to the Chief Justice, not as a direction. The Chief Justice would take it up and deal with it as a style with his judges at the Court of Appeal. Because the Court of Appeal can only recreate itself. We cannot go there and hammer them into recreation.
Thank you very much, my Lord. Let's move on. Just a couple of more questions. You've heard this phrase, why hire a lawyer when you can buy a judge? You familiar with that?
Very familiar.
If you do become Chief Justice, What would you do differently to deal with corruption in the judiciary?
One, surveillance. It is one thing to say that you're dealing with the corruption, and that this is a very thorny issue and a very, sensitive issue, because whoever would listen to me answer this would pick quarrels with me if they were in that side. Thank God I don't belong there. So, put effective surveillance mechanisms so that we are able to detect these cases. Corruption is a very personalized affair. It's not an affair which, is public or publicized. It's like any other very personal, areas of our lives. I don't want to mention them here. So that this two-way matter, unless the Chief Justice and his officers do very strict surveillance on this, and also deal with it very firmly, because we cannot sit here and pretend that we are serving justice when we are doing things under the table. If you are not writing a genuine judgment, then you have no business writing any. You should walk home. So that when these things are influenced by not even corruption, call it bribery, is that cheap? By bribery, you are telling us that we are not in serious business. So the Chief Justice should put his foot forward, should do surveillance and employ any other methodology, including the EACC or any other mechanisms to arrest corruption. The Kenyan public would never be happy like I would offer them if they were still being asked to pay 20, 30, 40 shillings, 1,000, 2 or 5. And it's so unfair, so immoral, that I will not kick anybody, but I will not be amused. I'll do everything possible within my means to eradicate this entirely.
My Lord, what mechanisms would you employ to ensure that corruption cases are heard and determined expeditiously, which is not currently the case?
Did we agree that, or did I submit that I would, in the next 3 years, I'd want all my matters determined in 360, or if you want to increase that, 365 and a quarter days, so that in every 12 months, a matter which has been raised with us is determined. We have an issue with the criminal justice because it is a broad spectrum. We have an issue with corruption cases. Corruption cases and what is hurting the Supreme Court, elections, is a class affair. It's very rare that you find people who are involved in corruption being my brother who does his beans and bananas at home. Not him. It's somebody like me, you, and everybody else. And do we call it class? People who are up there, the elite of this society. That is why it becomes very, very difficult to deal with this. But do we have judges in that court? Do we have adequate staff? That is the first question. Are they happy? Have they raised issues why they are not able to deal with these matters? You'd have to get the background material if you've not been there. When you get that, you fix it and insist that these matters are done on time. In fact, on time. And in the first instance, you should not have any matter which takes more than 2 years. The second instance, you are getting to 18 months. The third instance is 12 months, and it is doable. If the prosecutor does not want to do their matter, they can as well keep them or prosecute on their own. The Chief Justice Emeritus, my good senior, David Maraga, always told everybody, bring your evidence, we shall deal with it. If you don't bring your evidence, don't you have mechanisms for dealing with the matters? Because backlog, people bring their matters here and they go to sleep. You bring a corruption case or any other matter which is a criminal, etc., and you go to sleep. Litigation is a business. They are professional litigators. What they litigate, we do not know. I've learned that from those who are in the judiciary earlier than myself. Those who have worked in the judiciary have that advantage. My spouse was here for 38 years. She retired the other day as a junior officer. Don't get worried. The Honorable Attorney General. And we know that there is business in litigation. There is business in delaying litigation, etc., etc., etc. If we see it as a combined force of the judiciary, we'll be able to eradicate this, to stumble at.
My Lord, forgive me for interrupting you, but you've been a judge for 8 years. And even if you haven't worked in the corruption court, I assume that you have some knowledge of the workings and the impediments that face the judiciary. You are now Chief Justice. What practical steps would you take to eradicate some of these problems that you're alluding to?
One, identify the issues, the problems.
The problem is delay in determining cases that touch on corruption.
Get to the court and address the officers who work in that, the judicial officers who work in that court. Get to the court and address the administrators of that court. Get to the court and get their experiences. Why are we not able to deliver? Why do we keep a matter here for 3 years, 5 years, etc., etc.? When you have that, get to set targets, clear targets, which are permissible, acceptable, or doable. You will be able to know from the experience, you'll be able to give you data on what is doable and what is not doable, and why it is not doable. When you have all that knowledge within yourself, you devise strategies which make it work. I know it can work. I know it has improved. I don't want to mention names. I know it has improved, and it is coming out well. It can be done.
Thank you very much.
Honorable the Attorney General.
Last but one question, my Lord.
Please do.
Is the Judiciary Independent?
The judiciary is independent. I'm very, very happy about that. I've been here for in July to be 9 years. Nobody whatsoever has wanted to interfere with the matter I was doing. We can feign a lack of judicial independence, or we can be participants in that non-independence. When you create situations which mar or stifle or stumble your independence, like corruption, you are not telling me that you are involved in corruption and then you are also doing an independent, you are independent as a judicial officer. Zero. That is not the reality. The judiciary is important. I am a living independent. I am a living example. Nobody in 10 to 9 years has interfered with my decision making. Look at it all over. Who has come here to hammer anything on the judiciary? What haven't we done? Presidential elections? And they walked free? Very sensitive matters and walked free? Let us not point at anybody. We are independent. If there is an issue of lack of independence, then we shall say that we are our own worst enemies. We collude to create non-independence. So far as I'm concerned, we approve 1,000%.
What role do you think the other two arms of government should play in protecting the independence of the judiciary, and how would you as Chief Justice encourage that?
One, the issue of a constitutional government, starting from the judiciary, going to the executive and the legislature. And a constitutional government which also appreciates constitutionalism. We have had some very good writing by my good friend, the late Professor H.W. Okosogendo, Constitutions Without Constitutionalism. That is where we start and end. Because you are singing this, you are doing this. You preach this and take the other. If the other arms of government took constitutionalism seriously, this country would cure within a week. If we all took it upon ourselves to practice what is right, to eradicate impunity, we will not require a week. Do you remember the NAC revolution in 2002, which lasted only 11 days? We were there. We had it. We can have it. With the participation of all the stakeholders, the executive, the legislature, and ourselves. Combine and liberate Kenya. That is what we are called upon. That is why we are paid so heftily by the Kenyan taxpayer. Did I answer?
I'm much obliged, my lord, and that will be all for myself. Thank you very much, Honourable Chair.
Thank you so much. It's been a big pleasure, and always welcome, my senior.
Thank you very much, Your Honor. I would like to ask Commissioner Gishohi to continue the questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Yes, I'll be very brief because most of the questions have been alluded to, but do allow me, if you don't mind, Honorable Judge, just to focus more on the Commission. And I want us to remain with the Commission as much as possible. You have reflected on this period, 2011 to 2016, the foundation, 2016, 2020, 21, sustaining. I want to be very clear. If you get this position as the chairperson of the Commission, just one thing that you'll be able to do or to initiate to deepen, broaden what you are, what the Honorable Chief Justice previously in those two periods have actually put in place as far as the Commission is concerned.
Insofar as the Commission is concerned, on transformation, I would bring up the Commission to appreciate its position vis-a-vis the judiciary. One of the biggest issues we have today, and it was mentioned on Monday by my good friend Justice Chitembwe, is the issue of management of complaints. That is the elephant in the room. If you ask me, I'll write 1,000 pages. I'll tell you a story for 10 weeks on what it costs, the opportunity cost of answering a complaint.
Complaint?
So what we are saying is let the JSC take a decisive role in dealing with complaints. I don't know whether Commissioner Gishoyi, not Gishoyi, but the representative for Advocate Macharia is here, and I want to use my example. You want to please allow me that.
Without going through the details about it.
Yes, in 2013, I get a complaint. In 2015, we deal with it, and I am successful. In 2019, The same complainant brings a complaint against 6 of us. 5 in the Employment and Labor Relations Court, 1 in the High Court.
Okay.
And the JESC forwards it to me for answer. That is the issue.
Okay.
What is the capacity of managing these complaints?
Very good, Judge. That's a good complaint. I want you to look at the issues, and it was raised earlier on, that you are the chairperson of the commission, you're the Chief Justice. And I want us to focus on the organs of the commission. Organs, not individual offices, organs that you can utilize, that you can be able to touch, that can be able to make those changes. As chairperson of the commission, as Chief Justice, could you share with us those organs within the commission that you can either strengthen or establish or abolish?
I am not versed with the workings of the Judicial Service Commission. I will not score 40% on that one. But I can mention the areas which I would touch, and then maybe it can be linked to the organs, so that when like the issue of complaints, the body behind that one would have to be streamlined.
Two.
The issue on the growing of development would have to be touched on, because this is where our infrastructure is infrastructure and the other materials that we utilize, like the ICT is anchored. We would have to touch that. The issue of human resource
Good.
is very, very critical, because without human resource, we are as good as dead. We are not in business. We can have all the courthouses, all the buildings, all the it will not be any business. So those critically are the 3 areas that I would like to touch. Start with.
Let's take human resource, because that's very critical.
Yes.
And you talked about making the staff happy, not to fool around, and you talked about a result-oriented approach. I want us to focus on customer-oriented approach. You have been saying about being happy and the rest. Were you to have the customer-oriented approach to make sure the staff are able to produce in terms of productivity? What would be your targets? What did you do to make sure that you have a very clear strategy on how you are going to motivate your staff?
One, let us agree that staff will require facilities to motivate. Staff will require education, training, because I could as well give you an elephant, but you do not appreciate the value of an elephant. So it is not a serious business. Education and training to be able to understand where we are, what we are doing for them. I will allow staff to have their liberty. In fact, if I became Chief Justice, like I suggested 3 years ago in a colloquium, I would allow every officer of the judiciary in their respective capacities to, if they choose, form trade unions. Why? Because it is easier to deal with something which is organized than to deal with a hazard and amorphous things. Groups. We have quite a number of suits on salaries. We have issues of confrontations between the JESC and the staff. etc. This can only be achieved if we have a structured system for those staff members to deal with us. It would even be time years and a better way of dealing with it, because we don't have everybody working individually to deal with their matter.
Very good.
Please.
Talking about training and developing the staff, I want you to focus on the role of GTI. And as chairperson of the commission, where would you place GTI? What kind of facilities would you give that institute to make sure that it is able to give the service to the staff and to judicial officers also? GTI.
The JTI, today is not the JTI we had 8 years ago. JTI was big, it was brilliant, and it was very, very good. You'd go there and meet on international, conferences. The JTI I anticipated even from then was a JTI which was a complex. I'm not quoting or copying anybody. This is my experience the first time I landed at the JTI. A complex. We do an institution which is self-contained, which is good, which is good to go.
So what has gone wrong?
I would not know. Earlier I said that I'm not an insider, and it was not.
But Judge, you've been here for 9 years.
Is that insider?
Yes, 9 years, long enough. 10 years, kid is going to primary school.
I think we may have to revise our English.
Okay.
Insider means somebody who is actively involved in the administration of the judiciary.
Okay.
I am a judicial officer. I'm inside, yes, but at the periphery. Those areas are not mine.
Okay.
But on the JTI, that one, without even from where I am, because it's an institution I love so much. It's a place I value so highly. Firstly, give it the requisite personnel. We had a very good JTI in the reign of the Honorable the Attorney General. We had a very good JTI in the reign of Justice Professor Njagi.
Okay.
Excellent. It went diddling, I believe, because of finances and maybe administrative issues. I do not know. But what I will do is firstly facilitate competent personnel to deal with the institution. Secondly, deal with it, have international linkages. The personnel who go there must link it to the other international similar institutions or even greater institutions, so that it becomes a benchmark. We can benchmark with them. Infrastructure.
Okay.
We would have to do it well, so that you have been to the KIA. It has changed names. I can't remember the infrastructure. The KIA. Which is, I've been there twice, thrice, I can't remember, but it's an excellent facility for mobility in government. Government doing its own affairs.
Okay.
JTI should go that direction and even improve on that. Somebody suggested in the interviews that we should own it. There has been a resistance by the owners. That one I know. I'm a friend of the good Professor Njagi. So when that kind of issue arises, we should not stick there and moan that they are resisting. Look for land and start afresh.
Okay, Judge. Let's move on to something else now.
Please.
You're talking about financial independence of judiciary.
Yes.
Lack of funds.
Yes.
You need the funds. The Kenyans pay money, taxes to fund the judiciary. If you get the position as the chairperson of the commission, do you need the funds from government, from the exchequer? Would you share with us, as the chairperson of the commission, as the head of the other arm of government, what strategies would you put in place to ensure that we get adequate funds? 3 strategies, please. 3.
One, take care of whatever we have from the government of the Republic of Kenya, the Judiciary Fund, establish it, take our share and claim for more if it is possible. When we have that, we are well anchored. If that and it is not going to be enough, then we do fundraising. Fundraising is a contact with our friends and other stakeholders, so that they assist us in raising funds to do a magnificent JTI, buy some 20 acres of land and get money to do it and raise it in the next 3-4 years.
Those are
doable. Fundraising and donor.
Donor fundraising.
What we have not looked at is, being conservative in a way, prudent and a conservative user of what we have. Government is known for buying this pen for 500 shillings. I started using this pen in my TSC days. I don't remember what it was like, but I know this pen costs 230 shillings. At most 240. If I move to Prestige up here, I'll get it with my 230 and 40. So prudent utilization of what we have.
Okay.
We complain over nothing. We just abuse
Judge,
resources.
Honorable Judge,
Please.
you are the chairperson of the commission. You are the head of this arm of government. You are talking about the total budget of judiciary. Yes? And I want to hear from you as a chairperson of the commission. And you know the government cycle. I've seen from you for a lot of years. You have 17 years in AG's office, 5 years in the TSC as a public officer. I mean, how do you find other organs of government? What is the system? What do we use? Apart from fundraising, you fundraise for judiciary. The following day, somebody comes for dispute in your court. So I want to focus on that law. The Kenyans are responsible for funding national institutions. And you are the head of judiciary. You are the chairperson of the commission. How would you, the strategy that you make sure that you get enough funds?
You have to put in a hard bargain.
Hard bargain.
Our issue is history. From 1963 to date, how has the judiciary been treated in our national politics? What position have we taken? Below, even prior to 1963, how was it taken? Because we have had a judiciary here for the last 140 years. This is what we must dismantle.
Okay.
We must put out our foot forward and acquire our possession. When you acquire our possession, we must be able to say it very, very succinctly that you are not doing us a favor. Treasury, you are not doing us a favor. Of course, politely.
Okay.
Otherwise,
Treasury?
Otherwise you will not get anything.
You mentioned
But before you even get to Treasury, we have the three organs of government: the legislature, the executive, and they are headed by their CEOs. We have two speakers of the National Assembly. You will find it interesting to sit as government in totality. And when you sit with the government in totality, you don't even, nothing is not an issue of power, it's not an issue of possessions, it's not an issue personal.
Okay.
Let us do Kenya proud. And in that way, you'll be able to say, this is this, this is this. The biggest issue with Kenya is that we go very personal, not in government, everywhere. I don't know whether it's a human issue, humanity issue, or is a Kenyan issue. But we go very personal over very small things.
Okay.
And there we are. But you can get out of this.
So
You can teach everybody out of this.
Okay.
You can have organized and constructive discussion with the other heads of the other government
So
institutions.
if you walk into the National Treasury as the chairperson of the commission, where are you walking to in the National Treasury as the chairperson of the commission?
As the chairperson of the commission, I would walk straight to the cabinet secretary.
To the registration? The registration, to what office you will be walking to? In the
That is
registration?
executive. That is
The treasurer is okay. The CS. I'm now on the registration.
You go directly to the speaker, to the chief executive of the legislature.
To the speaker.
Justin Muturi and the other gentleman. Now that I'm under pressure, I may not remember his name.
Okay. So
You
then-
go to them and you chat it out. You thrash
Okay.
out issues for Kenya.
That's fine. To the executive?
His Excellency, the President of the Republic of Kenya.
Oh, very good. Finally, the judiciary, I'm sure this one you will have an idea, the Judiciary Leadership and Advisory Council. I presume that is more or less the cabinet of judiciary in terms of the internal organizations.
The Judiciary?
Leadership and Advisory Council.
Yes.
Are you aware about it?
JLAC. I am.
Yes. If you have to get there as a chairperson of that council,
Yes.
the first meeting or the first 2 meetings, what will be your agenda?
My agenda would be a review. Firstly, a review or an assessment of how far we have gone insofar as judiciary administration is concerned. And having achieved that, I would, in the next meeting, I would get to foment the way forward. I mean, where have we failed? What is our success? Do we have any balances? And if we have balances, how do we move? What is our way forward?
Okay. My final question, Madam Chair, Honorable Judge, you talked very passionately about staff and making staff happy. But you also need the staff to produce, to be productive, to be efficient. In the event that staff are not that productive or efficient, someone is behind the targets. As a chairperson of this commission, and those issues come to the commission from the Human Resource Committee, what kind of punitive or kind of collective measures or framework would you have, would you recommend?
With staff, these are human beings, these are persons.
Yes.
You would have to be very kamhadi, very cordial, etc. So that you get to win them. I talked about winning them or buying them.
Yes.
When they are with you, they'll be able to get back to Kenya and make Kenya happy. When an eventuality like yours comes, and they must be there because we are diversified, we are human beings. Our capacities, work is a gift. You're gifted to work A, B, C. They are the so-called lazy persons. That is the word we use. They cannot do as much. They are those who cannot do anything.
Carrot and stick. Carrot and stick.
By whatever name called, thank
Yes.
you. And you have to be able to know how to manage that. And human resource has got its own programs for dealing with that. We are not saying that we just want to make friends. No, we are making friends with a view to attaining something for this country. We want to transform the entirety of the country, not necessarily the judiciary. That is why our people must work and live, free Kenya
That's
to do
enough
their
for
work.
me, Judge. I didn't want to pursue it further, but finally,
Please.
you are in the TSC,
Yes.
and the TSC came to a point where you had to disengage
Yes.
without going to the merits or the merits of the matter.
Yes.
There was retirement in public interest.
Yes.
In public interest.
Yes.
Just very briefly, what was it about?
I have made mitigating circumstances. I have that here.
No, you don't have to refer. Just
One, nobody, I was given a letter headed retirement on public interest. The first notice was thanking me. The second issue was wishing me well, and it had ended there. In law, or even in practice, or in sense, when it is such a grave matter, which you must learn to live with, please explain and say, on this ground, etc., we retire you, and on public interest.
Okay.
Nothing. I'm still blind.
Okay.
I would have to walk to the TSC to know why I was retired on public interest.
Thank you, Chair. Thank you, Judge. Wish you well.
Thank you, and thank you again.
Thank you very much, Your Honor. Your Honor, would you want to take a short break?
I am okay, but I'm not speaking for anybody else. I am okay. Thank
You're okay.
you.
If you're okay, then you're okay as commissioners.
Please.
So I'd like now to call upon Commissioner Koskei to ask questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Mine will be very short. My first question is, if you are a CJ tomorrow, what are the first 3 things that you will check when you wake up in the morning?
The first one, and which will not take me an hour, is the issue of the 41 judges. Earlier on, I said that I would get the Deputy Chief Justice, the Acting Chief Justice, as we speak, the CRJ for a meeting in the next 1 hour. The next matter I would deal with is the issue of ascertaining our financial position, and the CRJ is here, so that is in our fingertips. And on that also, I would wish to understand from herself her operations. What is due? What is not due? How is it done? I do not know how it is done. She would have to teach me instantly.
Judge, let me interject. I really want to know. You see, when I'm asking you 3 important things that you perhaps will be, checking almost every day when you wake up. As you are entering when you are entering judiciary. No, 3 things. The first 3 things that when you wake up like this, you have to check as a Chief Justice.
One, I would have to compare notes with the Chief Justice to check on the issue of finances. That one is very critical because it can cripple us. In fact, the publicity itself is bad enough. We need not have stolen. When we have a story going around that this and that has happened to our finances, it becomes a crisis. We
Yes.
even we get ungovernable.
Number 2.
The second one is checking on the morale of our staff. What is happening in Nairobi? What is happening in Mombasa? Every other day you must ascertain that all is well. And if it is not well, you address that. The third one would be, that one would be on a performance. The Directorate on Performance Management, the CRJ and the HR, our heads of stations would have to constantly on a daily basis, maybe daily or 2-day basis, give us a brief on how we are progressing insofar as our service areas are concerned. So
Thank you very much. I think you've answered.
Please.
Now, my second question is on customer service. You are an insider, though you are denying that you are not an insider. 9 years in a particular institution will make you an insider in all the description and definitions in English. So, in judiciary, there is a problem when it comes to customer service, and the public are always concerned, especially a very long turnaround, time on payment of funds or fines, the funds of bails, and even the reception. If you go to courts, people get confused. They don't even know, they are no direction. People get lost. They are in corridors. Even some innocent people have been even jailed, as you almost jailed your staff. What strategies or reforms will you introduce to provide high quality and perhaps effective and efficient customer service in the entire judiciary?
One, I am not sure whether we have a policy on customer care or service. If there is none, we would have to do one in so little time. Where so little time means 90 days. When that is hard, the next issue is commitment to duty, morale in doing that work. I know 2 offices in the judiciary which are par excellence and which score a lot. I don't know whether they have the permission to they do an excellent job. One is strictly customer care, the bench liaison at room 440 up there, the registrar of the High Court, excellent. The transport derivation is excellent. Why have they been able to achieve that? Because of their morale, their commitment to duty. So you inculcate commitment. I need to be firm on this one, because how do you achieve satisfaction by the Kenyan public without good custom service? It will not be available. So you train, you cajole, you enforce and achieve. And those are things, if we have a policy, even without a policy, those are not the things you require 2 weeks to achieve. The CRJ is here, everybody is on the ground, there's nothing lacking. So it's just a question of a change of attitude. And that one you can get. If you have people who do not want to do that, you have your choices. You are an administrator.
Thank
and
you.
The rules of the game are known.
Thank you. You have answered, Judge. You have answered. My third question is on statutes that are always used to run the management of public institutions. And you know, there are 5 main ones. One is Public Audits Act 2015, Public Procurement Disposal Act 2015, Employment Act, PFM Act, and the Judiciary also there is Unclaimed Financial Assets Act. I've seen that you were in TSC, which is a public institution.
Yes.
And you are in charge of the legal desk.
Yes.
Which means that you are a member of the tender committee, obviously.
Yes, I was a member of the tender committee very briefly.
Now, and you must have interacted with the law, procurement law. I wanted to get your thoughts. You know, Procurement and Disposal Act from Exchequer and Auditors Act of 2001, and we came to 2005, the one that now you interacted with for almost 4 or 5 years. They had very clear objectives: transparency, accountability, value for money, etc., etc. I want to know, has this law, or to what extent has it, achieved its objectives, and what are the limitations of this law? Because you are coming in as a CJ, and every other time you are interacting with the CRJ on issues of management, issues of governance. I really wanted to understand, because this is one statute that it will be on your desk every day. Judge?
I'll attempt to answer your question, but not based on my exposure at the Teacher Service Commission or anywhere else. I am not exposed on this whatsoever. I lasted very, very little time in the Committee on Procurement in the Teacher Service Commission. Not 3 months out of my 5 years. I think there was a coup d'etat, and I was removed and concentrated on what I was supposed to do there. So on that, there's an issue of what we have as the law and what we have as the reality. It is one thing to have the law, it is the other thing to have it practiced. That is a big issue we are having with the Constitution of Kenya 2010, and that is why there is a lot of hullabaloo in this country. The same, going back to where you are starting, this is a procurement law. We say one thing, we do the other. That is where we are. So how would we be able to deal with that one? Monitoring, enforcement, and strict enforcement. We'd also be able to law as sanctions, deal with cases of defiance, deal with cases of infringement of what you are supposed to do, lack of due diligence. It requires monitoring. This is an area where we require a lot of monitoring, because as we speak, procurement in this country, virtually everywhere is an ISO. In fact, I'm very, very happy that to us in the judiciary, we've not had that kind of mammoth issues. Thank you so much, those who are involved in that. But we know what procurement is. We know the law is available, etc., etc. Why don't we choose to do the job? And because we know who we are working with, why don't we choose to deal with them so that they are able to produce? Why don't we choose to even retest our integrity so that we are able to do the good work? Buy this pen at 250. I mean, I would not mind. We are not going, I mean, the procurement laws are not going to allow us to walk to the bookshop out there and buy, I mean, formal stock. Personal, yes. But when we do that, let us do it without abundance.
Thank you.
That is the work of the CEO.
Thank you, Judge. Thank you, you have answered. My other question, which is my second last, is that currently there is a perception out there, especially from employers, that your court, that is Employment and Labor Relations Court, has been captured, that it is a court for a labor movement that gives direction, even to when the current constitutional amendment that is going on now. One of the most senior labor movement leaders said, you can change anything, but don't touch my court. And they refer to a court. What do you have to say about that?
We shall entitle every Kenyan to what they want to say, as long as it does not offend the law. It is their constitutional right. It is their basic human right. We entitle them to that. You are also aware, good commissioner, that labor is activist and a political issue. Very, very unfortunate, because we can do it professionally. But from the onset, it has always been an activist. So what the judge does is stay aloof to all that, so that you are able to do your work effectively and without interference. You stay aloof of any sector, whether it is the employers, whether it is the employees, and whatever they say. You just take it straight, like every other Kenyan would do that, and maintain your distance. What I would like to say about that is, like I've said, good enough. Let them say it. The other one, the other answer, they are saying that don't touch my court. Who are they telling not to touch their court? Good enough. Their court, that's plain English. Do they own it? That's another issue. Is that going to really influence decision making insofar as the court is concerned in government? Another one. Those are all issues which will come to the administration in this country, the political administration in this country. That is their desk. The judge sits here and remains neutral to his profession. Judgeship is a difficult matter. It's a job of denial. When you're a judicial officer, you must stay aloof, you must stay away, you must live alone. I thank God.
Thank you, Judge. Thank you, Judge. Now, let me end up by seeking some clarifications here. One is your card from People with Disability Council, I don't know the name, where it is written visual stroke mental, and you saw it the first day. It is now 6 years. You even went ahead and told us that a friend of yours who knows the repercussions or the effect of having that statement on your card, he told you to be careful because it can bring in issues. I'm not convinced that you just ignore it like that, because it's a very serious issue. The issuer of that card is a statutory institution that is technically qualified to recommend, and we cannot challenge in as far as their decision is made. But now that you are carrying that card for all those years, didn't it cross your mind that one day or one time you will be haunted by the writings on that card?
It has never occurred, and the judge, we have our own personalities, which we are entitled to. We have our own creations. I have over 340 leave days left, a balance with myself. I am a workaholic. I am not, my personal look is not myself. I'm missionary. I love it when everybody else is happy. So peripheral issues like that one, now it has become an issue today. I don't know for what good or bad reasons. I can address it. It just requires me a day or two. Unfortunately, I'm not a Nairobian, but I can invest that time there and have it done. But it never occurred to me that it was, if you ask me, it was a non-issue. When I was addressed by the expert, I said I would do it. But it's not in my style to just touch on anything which I have no regard for.
Okay, Judge, so are you saying you are going to amend it? Are you going there?
Instantly. In fact, tomorrow.
Okay, thank you. My other clarification that I wanted to seek from you is about this driver issue. Why are you so particular about one driver? I thought driving, you are driven to work, you are picked, you are taken home, even if you are passing by a supermarket, this normal way. Why do you want a Mwangi? Why not a driver that when you give instructions as like anybody else, like an average human being, he will do it? Why are you insisting? Why do you want?
I'm not insisting on Mwangi. We can get it back, or we may not be able to get it back.
Yes.
Foremost, I'll insist on all the monies are paid to my drivers if the issue becomes an issue. Referred of whatever I've expended on the drivers in the last 6 years, if it becomes an issue. I have a driver as we speak. He's around, Stephen Kiprop, whom I acquired in my Kericho and Eldoret days. We are buddies. He's just my small boy, 28 years, and good to go. I would have, I would have anybody for a drive as long as you are able to meet what my needs. And my needs are sensitivity. I cannot drive. Even if I would drive, I'm not a good driver. I am a person with issues of health. So if you leave the car here, I would have to carry it. That is what you are saying. So flexibility, understanding is very, very important. If I become CJ, I may require more than one driver. We can pick Mwangi.
Yes.
If I don't become CJ, I'm content with Stephen Kiprop. Would you want us to absorb him tomorrow? I'll be very, very happy. I can even forego what I paid them all these years.
But Judge, going to the extent of even, paying, looking for your own driver, don't you see it is like off the mark, like it is not ordinary, it is not like any other person. You are totally different.
Yes, I am totally different. If you give me time, I would be able to tell you where I'm coming from. I wish you, Chair, give me some 2-3 minutes.
Go ahead, Your
Honor. If you look at the MBTI, that is a Myers-Briggs type indicator, there are 16 personality types in the world. That is the science of personality. I belong to one of them, the INFJ. The INFJ is 1% of the world, at most 1.5% of the world. And not on sampling. You don't sample 100 people here and imagine that one of them will, they are randomly all over. So you'll never be able to know when you meet one unless he confesses, etc., like I'm confessing. I only learned about this just the other day. But all my life, I've always known that I'm not an ordinary person. I have my issues. There are some things I take so passionately. Everybody else takes them very casually. I is introverted. N is intuitive. F is a feeling. J is judgment. Those are my 4 qualities. The INFJs of this world are very introverted, very quiet persons. I could be in between INFJ and anything else because I'm just very verbose. What we are saying is that this is a special kind of person who is extraordinary and who cannot relate with everybody else.
So we have understood. So tell me now, you are applying for a position of CJ. You know that is a very senior position that you will be managed. You will be managed. Listen, you will be managed there. Sometimes even your diary is being managed by somebody else. You are guided. You are told move from here to there. There is this press conference. There is this meeting. They are talking notes here. How will you manage with you said F and something?
INFJ, you should have allowed me to complete that. That's half a minute to do that. INFJs are the best leaders in the world, but they don't go for it. They don't get out to get it. When you give them a chance is when you appreciate. And that is why this country should be given Njagi Marete for the Chief Justice. Because it will be extraordinary dealing with this situation, and the results will be excellent. Njagi and INFJ, I could give you other examples, but let me stop there.
Thank you, Judge. And finally, on the segment, I want you to, because these are the decision makers on whether to give you a job or not. Can you assure us that you will not come and say, I don't want CRJ, I don't want DCJ, I don't want these members of the Supreme Court, I don't want who, the other, even the way the building is organized. Can you give us an assurance so that when we are going forward, we know that we will not enter into a cost that we will not even manage to
I am not
bear.
going to take any Bible.
Thank you, Chair. Thank you, Judge.
I am not going to take any Bible and make any swearing whatsoever. But my personality tells it all. My policy as a person is one humanity, one equality. We are all equal. In any event, who would I be to come and dictate that we don't require A, B, C, D, and E here? It is demonstrated throughout my character that my personality is all-encompassing. We have my wife has been here for 38 years. I've been here for 6 years. No, not 6, 10 to 9 years. None of our children is anywhere near here. We have never aspired to bring them on board, etc. So there is no possibility that I would choose to work. Those who know me closely, Kericho, Eldoret, and Nyeri, those who know me closely and would like to tell a true story, know that I treat everybody on their own merits. And that is how I've dealt. I would be the last person to want to come and want to say that I don't want A, B, C, and D. It is not, I cannot even imagine it.
Very well, Judge. You have answered. Thank you very much. Thank you, Chair.
Thank you, Commissioner Koskei. Thank you, Your Honor. I now call upon Commissioner Orwande to ask the last set of questions. Commissioner.
Thank you very much, Chair. Good afternoon, my Lord.
Good afternoon. How are you?
My Lord, I like it that, like me, you believe that employee motivation and welfare is a significant input towards improving service delivery. And I'm aware that you once vied to represent the KMJA as a male representative in this commission. So I believe you're alive to our issues, and I'm certain that you don't believe that a ban to accompany the tea that we take at 10 o'clock would be motivation or a welfare concern. So I want to ask you, Judge, to give 2 issues aside from salary, and one which you've already raised, which is training, 2 issues which are welfare concerns, which if addressed would motivate the judicial officers and staff in this institution.
Accommodation is one. We have workers. They are physical, beings. We have no emotional attachment to them. It is good to nurse and accommodate our workers. That is the only way. If you don't buy them, like I'm saying and saying repeatedly, if you don't buy them, if you don't cajole them, if you don't accommodate them, there are issues. Most of them are very, very young people. They have children and baby. They are in the stages of babying, etc., etc. So their social welfare and all other terms must be accommodated by the employer very, very, very well to motivate them. You must recognize them, their humanity, their personality, their issues, etc., etc. I remember in Kericho we tackled a case of one of our officers who had issues with a drink, and very successfully, but it refused to work because of a relapse and what have you. We even took him to some place in South Nyanza as a gym. That is what we are saying. Let the employer engage more, invest more, not even invest in anything physically, emotional support, concern, love, so that we get home. Number 2, you don't work alone. You should be able to get these people together, either in gangs or one big gang, and then nurture that kind of a spirit of a group which we can call and tell them, we do this because of A, B, C, D, and E. If Kenya grows, we all grow. So get these people to tie together, like each other, nurse each other, assist each other, be a party or a partner to them insofar as their welfare is concerned, insofar as their unity is concerned, insofar as their harmony is concerned. Things which may not be very high sounding, but very, very important insofar as staff morale, staff productivity, staff welfare is concerned.
Okay, thank you, Judge. Do you believe in mentorship, and do you practice it? And if you do, can you give us examples of judicial officers, for instance, or judicial staff that you mentor?
I have friends in the judiciary. Mentoring would be involvement in that direction. I may not have any particular case of anybody I mentor, but I mentor in the air. I am a living teacher. That's why you find me shouting all over, and I don't give there are no issues about that, because wherever I sit, I'm teaching. By the time you leave this place, you have gotten so much from me. The teacher in me does not keep quiet. That is a part of my mentoring. Whenever I find anybody, how many people, anybody I find, yourself included, if we had 1 minute with you, have you gone back to college? Are you writing your other degree, etc., etc.? That is where I am, the personal development and concern for everybody else. Many of the workers in the judiciary are now my children. I deal with them as such. I nurse them. I parent them. Not that direct mentorship, but mentorship in a broad sense of the word.
Thank you, Judge. Now, you were once subject of investigation in a tribunal to remove you. And without necessarily going into the decision
Yes.
of the tribunal,
Yes.
I just want to ask you, because the issue that came up, one of the issues that were discussed in the tribunal concerned an order that you gave, which was considered sub judice.
Yes.
Now, I want to ask you whether you think as a judge, you ought to concern yourself or be guided by the consequences of your decision. To put it in context, in the matter before the tribunal,
Yes.
the allegation was that one judge in Nairobi had given an order against a strike notice. And the affected parties appeared before you subsequently and sought protection, essentially, from the consequences of disobeying that order. So that in the long run, you are in effect insulating these, the people before you, let me just call them the employees before you. You're insulating them against the consequences of the order that was given in Nairobi, bearing in mind that the order in Nairobi was given before the matter before you. Could you comment on that, please?
It is unfortunate that I have to engage on that one. This is a judicial service of Kenya, and they handle that matter. But shyly, let me tell you that one, you know the periphery of the matter. The matter was more complex. What happened is that the JESC asked me to answer that matter, and I did answer. And the answer I gave, I did not suppose that anybody would require any more efforts. I do not like this. To ask me.
I'm not even questioning the decision. The question I'm asking here is, as you make a decision as a judge, should you have a broader outlook so that the consequences of the decision, other than looking at the letter of the law, the consequences of the decision that you make, you take them into consideration as you make your decision?
You look at that, you are right. You must look at it 360 degrees. But as you look at it 360 degrees, when you're through the first round of 360 degrees, you must come back 360 degrees and ask yourself, should I not do this? What are the other consequences? So you have two sets of consequences. The set of consequences which would occur if you didn't give the interim orders, and this other set which would occur if you issued the interim orders. Now, and that is why this matter is so ugly. I answered all that because I cannot answer your question without referring to the substance of that matter. Allow me to get into that, just a little bit of it. I pray that we shall not be playing around with anybody else, because I would be so sorry. I'm a peacemaker. I don't like confrontation, but
you don't have to respond to the merits of the matter. It's just that concept I wanted to get, and I think essentially you have responded.
You must look at it all around, 360 degrees.
Thank you, Judge.
You should also look at the other way, 360 degrees. That is my answer.
Thank you. Still on the tribunal, but from another aspect.
Please.
You filed a case against the JSC in an attempt to arrest the proceedings before the tribunal.
Yes.
Now, to put the matter in context for us, and the rest that maybe would want to know, what were your grievances in that matter? And secondly, having gone through that process, are there any deficiencies that you noted that you would wish to have addressed or that you would wish to have us relook?
One, a good commissioner, that matter is alive and in court at Milimani. Petition number 88 of 2019 is alive. So we could be bordering on one or two things. Although sub-judice has been used as an excuse to run away from facts. I don't know whether I should move on to that, The JESC, to give a plain answer, as the pleadings or the advocates have the pleadings, it would be rude to say that the easier way would be to look at it. Or you invite me onto we are colleagues. You can invite me into a private sermon. We can deal with that very thoroughly. You'll be able to understand it. If you wanted to bring it out here and we thrash it, I think it would be ugly because it will cause confusion here. And we are warned, and very, very clearly in HR circles, that you don't go to your employer and start quarreling with him head on.
It's okay that if it makes you uncomfortable to address that question, it's okay, we can leave it. Now, maybe we can go.
The answers are very, very easy and very near myself, but it is not fair that we do it here with the JESC.
Thank you.
Invite me to a private section. We are colleagues, and the JESC and myself, we are all friends. I said I don't have any enemies, and we shall be able to thrash it. And I'll give you very satisfactory answers. And when I can't answer, we can research into it.
Okay, thank you, Judge. Now, sexual harassment. In the Judiciary Code of Conduct, sexual harassment has been given a wide scope. We have included in it the meaning assigned to it in the Sexual Offences Act, in the Public Officers Ethics Act, and in the Employment Act. Now, I was looking at the definition or the meaning assigned to the term sexual harassment in the Employment Act. Basically, it has been said to mean a request for sexual favors which contains a threat of detrimental treatment or a promise of preferential treatment. Now, considering the power dynamics at play in a relationship between a junior employee and a senior employee, would you say that a request of this nature from a senior employee to a junior employee has in it or has imputed in it either a threat or a promise of that nature?
One would have to get to the facts of the matter. Your definition of sexual harassment is respectable. When that happens, it truly amounts to harassment because there's no consensus insofar as the matter, the request or the lack of request, that interaction is not permitted by one of the parties, and therefore it becomes an issue. To be able to answer you precisely, you require to get to the facts of the matter. You require to get more evidence, more details to answer your question. But as we speak, misconduct to that extent, from a junior officer from a senior officer to a junior officer, or vice versa, by your definition, amounts to sexual harassment. And it is primitive, it is not permissible, it should be eradicated, it should be outcasted. My words.
That it's not my definition, it's the definition in the Employment Act.
Thank you.
And the essence of my question is, by virtue of that relationship,
Yes.
the fact that, for instance, I'm a junior employee, I'm a chief magistrate, and hypothetically, a judge of the Supreme Court is asking me for sexual favors. The dynamics of the relationship between us clearly, from where I sit, it can be implied, or it can be the element of threat or promise is sort of implied in that request. That's essentially what I'm asking. I don't know if you're getting my question.
No. You can relate to that. You have the liberty. Your natural human right to relate with anybody of your choice. And the relationships are not an issue of a status or office. A relationship is an issue of a consensus. You can relate with anybody. I don't want to give my example unfortunately, or your example, but where I say you, I don't mean precisely you, I mean any of us. So in that case, we would permit that kind of a situation, particularly if it is holy and out of for serious business, like marriage, etc. If it is not any other, although I don't want to be a moralist, we are saying the issue is not the office. The issue is the conduct of the parties or one of the parties. That is what would constitute the offense.
Okay, so I understand you to mean you do not agree with that analogy.
No.
Okay,
I agree with it.
Oh.
Only my clarification is that this thing is all round. You can relate this way. Anyway, the issue of status in a relationship doesn't arise. What issues we look for is whether it was mutual or not mutual, where there was a violence or not no violence, whether there was inducement or no inducement. That is what we look for if we were looking at it. The one that I taught my criminal law in law school, 80-81. I've done almost 0% of criminal law ever since. I'm not a criminal law practitioner, but I'm a lawyer.
Thank you, Judge. Thank you, Judge. I've gotten your answer. Now, I have looked at your application and the papers that you filed accompanying your application, as well as the reports we got from the statutory bodies through which we were vetting you.
Yes.
Starting with your application from JSC 2A.
Yes.
In your self-assessment,
Yes.
you described yourself, let me just read it.
I have it here.
I am a scholar who may have been misplaced at a crucial stage, as is demonstrated by my academic pursuits now at PhD level. This piqued my curiosity. What exactly did you mean by misplaced?
What I'm saying is that from day one I was a teacher. Somewhere along the line I maybe become maybe a lawyer, etc. I mean issues of influence, issues of status, etc. But basically what I was saying is this. I would have gone up the ladder and become a teacher in some university somewhere and enhance that to professorship. I admire what your name, good chair. I would have wished that for myself, and I may get it someday. After retirement, we are going to pursue these things. So along the line, things happened, and things which were out of our control, and we are not in that line. That is what I meant.
I was a bit concerned, Judge, because it gave me the impression that being a judge and ultimately maybe a Chief Justice is basically a plan B for you.
No. I chose to do law. One, because of my issues of justice and issues of service to society. But even in law, and I may not be Chief Justice if I was a professor in law, unless I choose to relinquish that and come back to this area. What I'm saying is that it is not an accident that we are where we are. But teaching, I'm a very big respecter of teachers. The other day I was accused of calling G.K. Kuria advocate, Mwalim in court, and there was an issue of a recusal, and it worked. I respect teachers. I mean, I respect intellectuality. I like research of knowledge beautifies me. In fact, these 2 months you've given me to read, I loved it. And that is where I am.
Thank you, Judge. Okay, again on your form, the form that you fill, JSC 2A.
Yes.
You are required to give a total of 5 referees, 3 professional and 2 character referees. You gave 5,
Yes.
but 4 out of the 5 were unresponsive when we sought their opinion on your character
Yes.
and you as a professional.
Did you get them in the first place? That could be the issue.
But what I'm saying is they were unresponsive. We did not get a comment from them. And this is of concern to us, and I'm wondering, do you know them, and would you know the reason why they did not vouch for you?
I suspect that it was a communication, their addresses. 2 of them are in the church, the personal referees, character referees. 2 of them are in the church in Mbagadi and up there on Gatarongai, etc. One is a church elder, the other one is a church minister. Those were the character referees. The others is my colleague, was my colleague at the Nazarene University, Professor Mbondenyi, some teacher of mine at Nairobi University, and an advocate who works at the Meru County and is also an advocate in Meru. I trusted him because I thought we were in school together. We had worked very, very briefly at the AG chambers before he left in Njagi, and I trusted that they are the limb of your question. When I issue referees, I don't go to them or even alert them that they may expect A, B, C, and D, or coach them. That is how open I am. I leave it entirely to them to give any information that you may ask, etc., etc. If you haven't, I am available now, today and tomorrow. I could carry those things to them. Dr. Akunga Momanyi, I cannot commit myself on that. Parklands is a difficult area, I may not be able to see him. As to whether you'll be willing to do a commentary on myself, I cannot answer that. He taught me about 15 years ago, 205, 206. This is 1610. This is 13 years ago in my LLM program at the University of Nairobi. I'm not even sure whether you wanted to do that. But teachers are the people we look for as referees in academics. So he has that, but I cannot promise you that I'll be able to get him. I'm not sure whether Professor Bodeni has done that. He's available. I can get him. So if you wanted me to pass these letters of inquiry to them, I would do that. As to answers, I will not bind myself on that, because the best I would do is pass the letter and leave it to them. And
okay, thank you, Judge. We were just concerned whether these people know you because they did not respond, but you've already responded to
they
that.
They know me very, very well.
Thank you. Thank
very
you.
well.
Next question concerns the wealth declaration.
Yes.
Before I can address that, maybe I would want to hear from you, Judge. Why do you think we require you to periodically file wealth declarations, and even at the time of filing your application?
The rationale behind wealth declarations was issues on integrity. The ESCC, and particularly you may call it right corruption. That document will be able to tell you that Judge Marete, before he came to the judiciary, owned bra. After the judiciary, A, B, C. And then you would have to make your own conclusions. You are sharp and good. Those who manage that are supposed to be experts. Even the best of idiots or fools would be able to look at that and see, now, this doesn't make sense. Judge Marete owns some property which is $500 million. I also would find it difficult to imagine that. So that is the essence of all declarations.
Thank you.
We do them.
It gives us an avenue to be able to probe and maybe audit.
True.
Thank you.
Yes.
I looked at your wealth declarations. You are required to submit 3, the last 3, and you did.
Yes.
But some concerns were raised, or I have some concerns concerning the declarations that you filled that give rise to my questions.
Please.
Judge, you earn a salary.
Yes.
That is income.
Yes.
In the 3 declarations that you filed,
Yes.
you've indicated your income as N/A. What does that mean?
Not applicable.
Why is that?
My answer to that is that in my own imagination, my cleverness or lack of it, is that when you're asking for income, you're asking for extra, not my pay. Because I imagine that you know my pay, everybody knows my pay, it's public knowledge. So it's extra income. Do I do business? Do I farm and sell produce? Etc. etc. That is why I answered it that way. If I thought differently, or if I had your idea of what income means, the answer would be very clear.
But you realize that we started off from the premise that that would help us do some sort of audit, so that we're able to look at, you gave the example that if someone said you owned a property worth 500 billion, we would question, on what basis would you question that if we do not know what your income is?
You know, well, declaration, the concept and the law came in 2003 after the NAC revolution in 2002. We have dealt with it from our TSE days, up to where we are. And all this time, my conception of income was anything apart from salary. That's
Okay,
where I
Judge.
went wrong. In the future, I am learning, and even on that one, if you wanted a statement on my income in those years, salary available.
Great, then you can supply us with that before this process is over.
My pay slips, I'm scattered all over. Some of my service in Eldoret, some of my service in Njagi. I have not moved from Eldoret. That may be a tall road, unless I ask my employer to give me extra details. If that, and I cannot work on anything which I am not in control.
Okay, let me leave that to you. Another concern I had about your wealth declaration is that
Am I allowed to ask a question?
Yes, Your Honor,
because
you
she
can
has
go ahead.
left it to me. Does that mean that I would have to do it, or it's left open? Because I can't see myself being able to go and go walk through Eldoret, get the pay slips, go to and those are old ones. Those are many years ago. It may not be practical before you clear the exercise. But I can promise you that, say, the next how many months? We are in before the close of the vacation, in the summer vacation, in September, I'll be able to give you that. And if you require it, then please tell me so that I can look for them.
Commissioner, or rather, maybe you can explain how many. I think it's the last one that you need, not all of them, or the latest.
okay, Judge, the advertisement required you to supply the last 3. You supplied.
Yes, all declaration forms.
Yes, you supplied for 2016, 2018, and 2020, and all of them had that anomaly. They did not have.
It has been permanent from 2 or 3.
Yes.
Yes.
And what I wanted to say is that the advertisement was there, and it is for you to comply. That's why I said we are leaving it to you. If you are talking about September, I do not believe that this commission will put this whole exercise off until September, when you can avail your wealth declarations. So I still maintain I leave it to you, or we leave it to you, to see if you can supply with whatever necessary information that we may need before determination is made. On the next issue,
Judge, you can finish what you're saying, Your Honor.
Yes, I was moving on to the next issue that I have with your wealth declaration, if you can permit me. Again, in the description of assets, where you are supposed to indicate the assets that you have, I noticed that you did not disclose your bank accounts. I do believe you have bank accounts.
Yes.
Or at least even a bank account.
Yes.
You did not disclose that.
Mm-hmm.
I also noted that you did not file a separate statement for your spouse, as is required in the guidelines on that form. And another crucial one that I noticed is that in the wealth declaration, the last wealth declaration that you filed in 2020,
Yes.
you had acquired a new property
Yes.
somewhere in Ngong
Yes.
worth 30 million.
That is not a new property. Good. Please ask your question and finish so that I can answer.
Yes, the challenge I'm having,
Yes.
again, on the same premise that we had agreed on earlier, that these declarations help us to make an assessment and do some kind of audit. You do not have a commensurate loan, because I would imagine probably it's a loan or a mortgage that you've taken
Yes.
worth that amount of money. Your
Yes.
income has not been indicated.
Yes.
This property worth 30 million
Yes.
does not appear in your wealth declaration of 2016
Yes.
and 2018.
Yes.
So I presumed it was acquired between 2018 and 2020.
Yes.
So-
That property worth 20 million is
30 million, my
my
lord.
home in Ongatarongai. I entered that property on the 1st of September 1996. It was 30 million even before I got to the TSC. So 30 million even before I got to the judiciary. So if it is not appearing on my other wealth declaration forms, it is an error. It would, and I believe I should have, and I have always wanted to it is my prime property. In my own imagination, I always give it as a part of my wealth. And if I have not done it on any of the others, that is an error. I can correct that by in a write-up or any other by any other means. That is a property I've owned almost virtually all my life. 1996, and today is almost 30 years, or well over 25 years.
Okay, thank you, Judge. I just want also to bring it to your attention that we, in the process of vetting, doing background checks, we received a complaint from one Eric Kiprono H. We received your response to it, and I do not have questions to that. I will leave it for the consideration of the Commission. Thank you, Judge, and I wish you well.
Chair,
Yes, Your Honor.
I have issues with the Commissioner. She has raised an issue on bank statements. She has raised an issue on my wife's income, and lastly on the complaint. There's something I did not get, and when I get all these, my question will be, does the Commission expect a response on this? I have noted bank statements, I've noted my wife's income, and I've not answered it. I could answer that, be allowed to answer that, or be enabled to answer that. The complaint is done itself, I answered. So what was the other issue?
Judge, if you have an explanation, please feel free to give it. An explanation as to why you did not file a separate statement as required for your spouse, and any other issue that I have raised. Please feel free to give that explanation.
So there are three issues. The issue of my 30,000 property.
That million, Judge.
30 million property, the issue of bank statements, and the issue of my wife. Do I answer the one for my wife and then have a balance of the two?
Please answer whichever you want to answer.
Yes. My wife is a retiree. She retired three years ago. She is not doing anything. She's around 63 or so years. She's just at home and resting. She takes a pension from the judiciary, 33,000 shillings, and eats it. Number two, misconception or wrong interpretation. All my life, from 2003, and that is why these things are bringing issues to me, I construed wealth declaration to be personal, and the issue of salary, the issue of bank account, the issue of my wife never arose to me. I'm learning now, and in the future I'll interrogate that and comply. So if that answer doesn't satisfy you, insofar as my wife's declarations, when she was in the public service, she would do hers, I would do mine. That was 3 years ago. She is not now. She's a pensioner. She takes her 33,000 shillings every month. Eats it or throws it away. That is not a matter which would really concern me so badly. But if you require me to do a write-up to that extent, I'm available.
Judge, like this is coming out of the vetting process, and this process continues until the commission makes a decision and nominates one of the 10 candidates. I just thought I should bring that to your attention. And what you are required to file under the Form 2B is a separate statement of your wife's income, assets, and liabilities. She may have retired 38 years ago, after serving for 38 years, but she may be having some assets. She has an income in the form of a pension. She may be having liabilities. That is what you are required to file. Thank you, Judge.
Thank you. We shall comply.
Thank you, Judge. And just to emphasize what Commissioner already has said, that we still have some time to submit those documents because we can still consider them until we make a nomination.
Thank you.
Thank you. So, Honorable Commissioners and Your Honor, we have come to the end of this interview. And Judge, thank you very much for coming, and also for your answers and the discussion that has happened. Thank you for being very patient with the commissioners. I would like to give you a chance, Your Honor, to tell us anything that you would want to tell us, or ask any question at this point.
Thank you, good chair of the commission. I must thank you so much for firstly affording me an opportunity to engage you on this auspicious occasion of the selection of the Chief Justice of the 15th Chief Justice of the Republic of Kenya. It is such a honor. Even allowing me to be here is a privilege. I appreciate and thank you so much. I thank you for the openness. I thank the people of Kenya for opening it up. We had days when this would not have happened. Two, you remember the INFJ, the extraordinary leader? Here he is, a leader without any followers, a leader without office or portfolio. If you wish to do Kenya a favor, and a big one for that matter, here we are. We offer ourselves to demonstrate to Kenya that these things are doable. And we can do them in style and simplicity. I am simple, I am straightforward, I am reliable. I'm very, very focused and outrightly extraordinary and organized. If this is not the person we're looking for, we can debate that. But in me, you have that and extras. Thank you so much. When you sit and make your final conclusion, remember that messages come in the air. And to me, Kenya has spoken. And there we are. Thank you so much.
Thank you very much, Your Honor. We have heard, the commissioners have heard what you have said about your personality description. Did you call it INFJ?
FJ. Google B Myers MBTI, Myers-Briggs Type Indicator. You learn the whole science of a personality type.
Thank you, Judge.
MBTI.
We have heard and we wish you all the best. And once again, thank you very much for availing yourself for this interview.
Thank you.
Thank you.
And some water, or do we have water?